Another tip too, recognize the steps that are required in the lien process. We have a lot of people say, "Don't worry, I can lien the job." Well, you can, but you need to make sure you know what the statute says you have to do. And that means knowing that in a majority of states, the lien process has 3 steps. First is some sort of a notice that's generally required. Second would be the lien, the actual encumbrance. And third would be suits to foreclose. All of these steps are typically prerequisites that I have to take in order to preserve my right to take the next step. So if there's a notice required, I need to serve that within the time frame that statute says, or there's a good chance that I've lost my lien rights. So in some of these states, the notice may be required to be served very early in the project, 20 days from first furnishing. Missing that deadline probably means I've lost my lien rights. So know my furnishing dates. Furnishing dates, typically that's what we're going to base our deadlines on. First and last furnishings are the most frequent. First furnishing is the date on which the claimant first provides materials or performs services on a project. Typical examples, if I'm providing materials, the date the materials first arrive on the job site. If you're providing labor only, the date we first step on the job and start working. If you're providing materials and labor on the project, normally the first date there is going to be when my material got there. So that's first furnishing, and a lot of my notices are based on so many days after first furnishing. Then we move to my lien deadline. My lien deadline is typically based on so many days after last furnishing material or labor. So last furnishing is the date in which the claimant last substantially furnishes materials or performs services on the project. So some examples of questionable last furnishing dates: punch list work, warranty, remediation. The key when using last furnishing is it has to be substantial. You can't just go out and kick up some dirt and believe that you've reopened your lien rights. So also, another important part in the lien process is understand the difference between full amount and unpaid balance lien states. This is important. It's about 50-50. Half the states are full amount, half the states are unpaid balance. An unpaid balance lien state means the amount of my lien is going to be limited very typically to what is unpaid by the owner to the general contractor. That's an important difference. A full amount state doesn't care how much is unpaid. A full amount state puts the onus on the owner. If I file my lien, the owner is responsible to make good on that claim. In an unpaid balance lien state, though, that can limit. If it's $1 million contract between the owner and the general contractor, and the owner has paid all $1 million out of that general contract, and I file my lien for $200,000, I filed an empty lien. The unpaid balance nature of that state tells me there's no money left. I filed the unpaid balance, there's no money unpaid, so I have the empty lien. So we want to be aware, what is the state that I'm working in? If it's a full amount state, I can breathe a little easier. If it's an unpaid balance lien state, I need to be a little more diligent and probably pull the trigger and file my lien a little sooner than I originally anticipated.